stakeholder consultation include with politicians or members of the Public Accounts Committee?
Apologies. Yes, the chairperson of the Finance Committee kindly gave time to the exercise.
Okay, so but would there be market research, for example, with politicians or members of the Public Accounts Committee?
Not by me. This was just a stakeholder communication.
No, it may have been somebody else, but certainly I received a call asking me my views about the National Lottery and how much I thought was spent on good causes and how much retailers got and so on and so on and so on.
That sounds like
it may
the
not have been
operator.
you. It does. Perhaps it was, and indeed we'll have the opportunity to ask them in great detail about that. Did you?
Yeah.
Oh, there you go. Did you? Sorry. There you go. Okay. Well, so it wasn't you.
No.
No, there we go. Can I go back to this point about your investigations around the 98%, 2%? Because you said to my colleague there, Deputy Kelly, that you considered it and you worked out that there wasn't an issue. Could you just tell me what process did you go through professionally, personally, to work out what you did? This shall-may issue.
Well, we have. I have the head of legal and compliance in my office is a qualified solicitor with many years' experience in private practice advising clients, and also has worked in public sector enforcement previously. So I did ask him to review the clause and establish what did the shall, the shall and the may, and what it meant, and did it mean I should be doing something to ensure any particular level of expenditure under those headings.
So you took internal legal advice?
So I took internal legal advice.
Did you take any external legal advice?
I don't recall taking external legal advice on this one.
Because I think we pretty clearly as legislators in here look at the words shall and may very differently. I'll give you an example. I mean, you said you came from a corporate regulatory background, right?
I have a qualification. I've studied regulatory governance, yes.
Okay. Well, a lot of that is about what you're allowed to do and what you're not allowed to do, and what you're permitted to do and what you're prohibited from doing. So say, for example, Section 17 of the Companies Act 2014 starts about a company may be formed, as in it has the permission to be formed for any lawful person by such and such and such and such and such. But the liability of a member of a quorum shall be determined at, right? So they mean different things.
Yes.
May is a permission. Shall is a prohibition or a mandate. They're totally different things. May not is you're not permitted to. But so if I say in here, you may not smoke, it doesn't mean that you're allowed to not smoke. It means you may not smoke, you must not smoke.
Yes,
right?
I understand, yeah.
Yeah, but it's a real difficulty for us because the licence is written, although the licence isn't a statutory document, it is written in what we would conceive as being very clear terms. Thou shalt not do something, but thou may do this.
And if it said you may put money into top-up prizes, we might have had, I don't know, would it have been 0%? Because it would have been may, not shall. But the other thing is, of course, as you know, is that when you read any clause of a contract or a licence, you read it in the context of the entire licence. And in the context of the entire licence, incremental marketing is defined rather circularly as not base marketing. And in some ways that makes it explicitly clear that when they're promoting the National Lottery, they are not in breach of their requirements to spend base marketing money by also doing
I honestly think that's a distraction, if I may say. I think what you have is two elements of this. You shall use it for this, and you may also use it for that. But the proportions are directly inverted relative to the obligation and the permission there. So you've got 2% shall, 98% may, and as well with the licence, even if you didn't accept that reading is correct, and I think it is, you as a regulator have a significant persuasive authority, irrespective of the terms of the agreement. Did you ever write to the operator and say, within the terms of the licence, I'm concerned about the balance that you're achieving, would you like to reflect on that and come back?
No, as I said, my advice and my understanding is that it doesn't prescribe that they should, say, spend more than half on one form of promotion and the other half on another form. And it also explicitly says in it that it is entirely at the discretion of the operator. And in general, there are certain areas, for example, where I am explicitly permitted not to intervene and make a judgment call as to how they should be spending their money or decisions they may be taking. Another one is...
Is this one of them?
And in that particular case, yes, I cannot intervene and tell them how much money to spend on social media advertising.
No, but that's
and how
a
much to
different. But
spend
there's a
on
different
this.
thing, and I think particularly as TDs, we know we don't often have authority in a particular thing, but we have a certain persuasive authority by highlighting a particular issue one way or another. And I think if this was a 40, 60, 55, 45, I'm not sure we'd be having this conversation. But 98% of that money being spent on advertising is a big difficulty for us, and it is a question around what is the reaction of the controller of that and what steps have been taken, because what it appears is that the National Lottery have used their discretion to spend an overwhelming amount of their money on their own self-promotion, and we can get to how that's linked to problem gambling and other things, and indeed as Deputy Murphy has outlined. So, you know, what we may consider is some misleading information in relation to good causes and the spending. But you're the gatekeeper of all of that. And the license. First of all, I suggest to you that the interpretation that you were given in relation to the obligation and permission is incorrect, and that you probably should have sought external legal advice, especially when the conversation is at the level of the CNAG, being highlighted and coming to the Public Accounts Committee in relation to it. And the second thing is, even if you hadn't done that, I suggest you have significant persuasive authority, and that you may have had the opportunity to write to the operator and query or find language that allowed you to query whether this was in fact the balance that was suggested by the licence.
Just to pick up on one thing, and that I wouldn't say they're spending it on self-promotion, they're spending it on promoting the National Lottery, which in turn benefits, but that in turn benefits good causes.
That's the same thing. That's the same thing.
I don't think the increase in good causes monies would be as great if they didn't have this advertising budget. But
okay,
I understand.
Sorry, let me ask you a different question then, right? It's in your own report that, in your own annual report, that there was an operator breach in 2021. There was 48 players who had self-excluded, and they were received marketing information from the National Lottery within 36 hours of having self-excluded. Yes. Now, if I go on, or as Deputy Kelly says on my app, the National Lottery has technology that's capable of taking my money immediately, whether it's from my phone, my bank account, or indeed my bank card. They're very efficient at taking my money. But it appears that they weren't quite as efficient at managing their own systems to make sure that people weren't getting information who had actively self-excluded for a 36-hour period. Can you imagine what a difficult thing it is to self-exclude from an addiction? And then to receive information at the same time, and the capacity for harm in that 36-hour window. And it is my understanding from your report that no further action was taken by you in respect of the operator on foot of that. Is that correct?
Well, once it was, because it had been resolved, sorry, I should maybe make that clear, but because it was fixed. So I completely agree with the...
Fixed? What do you mean it was fixed?
It
was breach.
Yes, but the thing that caused the breach was fixed in the sense that the system has been improved.
Was there any assessment of harm done? Did anybody speak to the 48 people?
We did assess whether or not they had, got back into their accounts to play, which they hadn't. So the lock on the ability to go back into your account and play worked, and they weren't able to play. So for each player, I completely agree with the Deputy, by the way, about the seriousness of it, and that's why I found it to be a breach. That even in most cases the player got one email within a few hours of excluding, and sometimes, but that's not acceptable.
I determined that the operator had breached Schedule 9 of the licence and concluded no further action was required. What further actions were available for you to take under the licence?
Yes,
under the Act?
So the full paragraph details, I suppose, that the operator didn't make any money from sending that email to the person or harm the reputation of the National Lottery. And
I'm concerned about the harm of the person, not the lottery, not the operator.
Yeah, exactly, absolutely. And for them to go and further contact a player in that situation could be more triggering for the player, so could do more harm than good.
It doesn't have to be. It could have been you. It could have been somebody else.
That would be the same.
It could have been Gamblers Anonymous. It could have been. But what I'm asking, what was done to assess any harm done to those people because of a breach? Because a breach occurred by the operator. It was noted and found by you. You took no further action. So the operator got off on it, essentially. But what I'm not hearing, and maybe the National Lottery can tell us this when they're here, is what assessment of harm was done to the people who had proactively self-excluded to protect themselves from their own addiction.
So the only way to assess, first of all, we assessed whether or not they were able to play. Secondly, if we consider, I did consider whether or not they should be contacted. But and I have an expert on player protection in my office, who's a chartered psychologist and specialises in research and on problem gambling and advises me. And the advice would be that to contact those people would be further triggering to them more than just like the one or two emails they got, and that would do more harm than good. And in terms of what further action is available to me to answer that part of your question, the one further action that is available, pardon?
Did they get an apology?
But that would be contacting the player further and sending them another email, which could be considered more marketing the National Lottery. It'll come saying, hi, we're from the National Lottery, we're terribly sorry for having contacted you. So, but what I did, look, the one further action that's available to me in respect of the operator as opposed to the players is I don't have the power to fine them. I have the power to withhold money from them for certain failings, and it didn't meet the test. And some of those items that I listed as, that hadn't happened are the things that I have to consider in order whether I can withhold money for them for failing to deliver the National Lottery. So they didn't meet that test in that particular circumstance.
It's a matter of interpretation. The legal point that we made earlier, I think you should have got external advice in relation to that. I think that interpretation is wrong. Clearly you have a player protection person within your office, but what I would say to you from the perspective of the state, from the perspective of the state on behalf of the citizen, it appears from your answer that what we're concerned about is the operator, the regulator, the communications by the operator would be further triggering. At no point does it appear that there was a calculation about, well, how do the people feel? And is there any other person that could have contacted them, could have apologised to them, could have delivered a measure of respect to them on behalf of the lottery system generally to say, we are terribly sorry for this egregious breach. You are, in a difficult situation. We would like, there are multiple other routes to contact to find a way to reach those people. And it appears to me that the concern was within the licence, very narrow, the relationship with the operator. And what I would suggest is that there's a much broader perspective that's important and that could have been considered in that as well. And I also find it just problematic that there could be 48 breaches, 48 players breached, and that no action would have been taken in respect of the operator. I find that difficult.
Well, there was action taken in respect to the operator. They were found a breach of the licence, and the breach was published, and
that's
it sits on their record.
What your own report says, no further action.
No further, in addition to the finding of the.
But that's not enough.
Well, that's
the only way that's coming out is in this conversation today.
It's in the annual report.
Chair.
Thank you.
Sorry, Chair, could I just not to lose the point, did you withhold any money? Have you withheld any money?
No.
For no reason?
No, there is no.
For any reason?
There is no power in the Act doesn't provide for punitive sanctions. So there is no, that is the way the National Lottery regulatory framework is designed. And the power to withhold money is in the licence. It's a contractual power to withhold money in certain circumstances. And to date, it has not. No money has been withheld from the operator.
In any circumstance?
In any circumstance.
You've never used these powers against the operator for any reason?
I have considered using them on a number of occasions, but there has never been a breach of the Act or licence that warranted the exercise of that power.
So the worst that's happened is that they had breaches and it's been noted in your annual report?
It's been published in the annual report, yes.
Right.
Yes. No, sorry. No, so there have been a number of breaches found, in advertising or, in this case, this was sending marketing emails to players who had self-excluded. And I completely agree with the deputy that this is very serious to do that.
What would the operator have to do in order to get a breach worse than being noted in the annual report, in order for you to use any of your consequences? Like, how bad does it have to be?
They would have had to have done something where they'd met the test that about what you can withhold money for. I tend to think of the test, because it's a contractual power rather than a punitive power, but nonetheless I tend to think of it a bit like if a strawberry farmer was supplying strawberries to a supermarket and failed to turn up with them and the supermarket didn't get to sell their money. That's one way of looking at it. Sorry, it's maybe not a very good way of describing it, but they would, if they there's 8 or 9 different factors that have to be considered to decide whether or not to withhold money.
But contacting people who've self-excluded is not one of those things.
The
contacting
consequences.
problem gamblers who've self-excluded doesn't meet that test.
It doesn't meet
strawberry
the test.
farming.
Yes, maybe there isn't a good example, but you know, it doesn't meet the test set out in the licence.
Okay, thank you.